Good afternoon and welcome to today's webinar coming to you live from Tillich & Gibbons in Ho Chi Minh City. Our session today, as part of this year's Regional Employment Law Forum, will be an update on employment law from Vietnam with the title, A New Labor Code and a New Normal. And our speaker will be attorney Truyn Hong Hu Lê. Before we begin today, as a small housekeeping point, our speaker will have some time for Q&A at the end of the session. However, if you have questions, you can submit them at any time by typing them into the Q&A box to the right of your screen. If you don't see that box right now, you can access it by clicking the speech bubble icon. It's the one with the question mark in it. So please do type those questions in throughout the session and they'll be addressed at the end to the extent we have time. Also, as you may know, this webinar is part of the ongoing Employment Law Forum series from Tillich & Gibbons. And if you haven't signed up yet for other webinars in the series, we're coming from Myanmar tomorrow and Laos from Laos next Tuesday, December 1st. There's still time to do so. There are also videos available of the previous sessions from Cambodia and Thailand if you missed them. And you can email events@tillich.com to sign up for or to request access to any of those sessions. That's events@tillich.com. Okay, with that out of the way, it's my great pleasure to introduce today's speaker. Truyn Hong Hu Lê is an attorney in Tillich & Gibbons Corporate and Commercial Group in Vietnam. Based in our Ho Chi Minh City office, Truyn specializes in labor and employment, foreign investment, corporate services, regulatory affairs, and commercial transactions and M&A. She also handles anti-corruption and competition matters and is regularly engaged by companies to conduct compliance training sessions for staff and business partners. In her 12 years of legal practice, Truyn has developed a reputation as the attorney of choice for foreign companies doing business or seeking to do business in Vietnam. And she has advised some of the world's largest companies, particularly in the life sciences and healthcare sector, on localizing their work rules and labor practices in the jurisdiction, as well as dealing with and avoiding labor disputes. So without further ado, I'm pleased to hand it over to Truyn. Over to you.
Yeah, so thank you, Eric, our country marketing manager, for introducing me to all of you, and it's great to have a chance to deliver the presentation about a new labor code and a new normal for you today. So he just helped me finish the first slide of my presentation, so I will move quickly to the next slide. Here we are. So there are 4 parts of my presentation. The first one, I'm going to introduce to you the most updated information about the investment and the labor market in Vietnam for the first 8 months of 2020. And the second part of my presentation, I'm going to introduce you about the new labor code, but not all the whole labor code is could be too much. So just share with you 10 notable changes that you should be aware of when the new labor code becomes effective on January 1st next year. And after that, we will discuss about the new normal. This is the most commonly used term in Vietnam during the COVID-19. So we have the term, the new normal. So what is the new normal and what are the things you guys can expect under the new normal? And last but not least, labor discipline. Okay, so labor discipline is always a need to be a focus. So, and after the table of contents, we will move quickly to the first section of my presentation. The good news is Vietnam has been resilient in 2020. So all of us have been aware of like the big impact of the COVID-19 for all around the world. But fortunately, Vietnam has been one of the best places to do business, and you may be wondering why. And I'm going to share with you some main reason as below. First, we have been through effective and brief lockdowns. And thanks to the lockdowns, almost all businesses have been reopened since June of this year. And the second reason is that as of yesterday, no community transmission in 83 days for the whole country. And I'm Eric based in Ho Chi Minh City, and actually at the end of November, assuming that no community transmission happened, we will have about 4 months no community transmissions in Ho Chi Minh City. And the third reason that we can confidently say that Vietnam's COVID-19 response has been one of the most effective in the world is that we are a country having 97 million population, but thus far there has been only 35 COVID-related deaths in comparison to the world average, which is like 182. So this is very like positive figures. And it's just before this webinar, I myself and then our country marketing manager got a chance to visit the official website of the IMF, and so we have two good news for Vietnam. The first one, as you can see, that the IMF report say that thanks to Vietnam's swift action to contain the health and economic fallout of COVID-19, growth this year is expected to be 2.4%. So this is like among the highest in the world. And just to share with you, just 1 month before November, which is on October, the expected GDP growth of Vietnam is 1.6%. So it just has been increased on November. And if this is any one of you or your company intend to do a business in Vietnam or intend to expand your current business in Vietnam, so according to the IMF, this is another good news for you. It is expected that the GDP growth of Vietnam next year, 2021, would be 6.5% as normalization of domestic and foreign economic activity continues. So it looks like Vietnam has a very positive picture for economic growing this year as well as next year. Because of what I've just mentioned in the previous slide, Vietnam is considered still a top investment destination. And if you look at some numbers, I'm going to share with you now. In the first 8 months of 2020, the capital was registered to be invested into project into Vietnam just reached 19.54 billion US dollar. So, and then, can you guess? The leading investor, we have 3 leading investors, and Singapore looks like Singapore beat like Korea and China to become like the top one leading investor in Vietnam. And just a few major investment projects we have in 2020, and I have been noted that most of the attendees and audience today are from Bangkok. So you can look at the second bullet point. Thai investor of South Vietnam petrochemical complex increased investment capital by 1.386 billion US dollar. So thanks for the Thai investor. Yes, and we are talking about employment law forum, right? So we move closely to the focus matter, the labor market. And the good news that the labor market is recovering. Foreign investors remain interested in investing in Vietnam. Although a number of investment plans were put on hold because of the unpredictability of COVID-19, but so far so good. And actually, before June of this year, there were several layoffs as well as like suspension of labor relationship in Vietnam, but it just started from November of this year. The labor market is beginning to thrive again. And though we are coming at the end of 2020, many companies are still keen to recruit new employees. And this is one good news. There are more companies, they started to rehire the employees that were just laid off in the previous months. And I'm going to share with you like a true story of what actually happened in Ho Chi Minh City. So in Ho Chi Minh City, we have like a one famous foreign invested company because of the huge labor source they have. So before the COVID-19, they have nearly 62,000 employees. And that company belonged to a Taiwanese investor. And because of the COVID-19, they need to work with the labor authority to perform the layoffs of nearly 3,000 employees. And they also need to suspend the labor contracts of another 3,000 employees. But this is the good news that it just starts from this November. They start to rehire for about 2,000 laid off employees. And the reason is that they explained to the labor authority was that they started to receive more purchase order from abroad, and they are doing like exporting of sport shoes. And then when they started to receive more POs, so they rehire the laid off employees. So this is a good news for such employees. And the rehires and as well as like the recruitment comes along with like a more comfortable salaries and benefits. And if you look at like the two remaining points of this slide, many big investors such as Samsung maintain their satisfaction with the labor force in Vietnam, including workers, engineers, and managers. So, because Samsung still plays like a very important role in the investment market in Vietnam. During the COVID-19, the Korean government and the Vietnamese government had cooperated to maintain the smooth working environment for the workers, engineers, and managers who work for Samsung in Vietnam. And plus, the last point of this slide, we're talking about like the labor costs. And again, the labor cost for Vietnam is still a very attractive and competitive compared to neighboring countries such as China. Third, it's very likely that, and we're confident that Vietnam will continue to attract more investment. And from your position as your investor, or to be investor in Vietnam, what's coming in next year in 2021? First, of course, the new labor code, the one that will take effect on January 1st next year. The good news is that most of the changes are not big, but some are still worth noting, and that was why I'm here. Because otherwise, if all the changes are not big and there's nothing still worth nothing, I didn't get a chance to be here today and to talk to you, right? Okay, and then as other countries continue to fight COVID-19, Vietnam has cautiously moved to the next stage with the hope that the impact is short-term. I think that not only Vietnam, but other countries, they don't want like a long-term impact of the COVID-19, right? And so it makes sense. And last thing that will be coming in 2021. Some of the changes brought about the global pandemic will remain, and in the next few slides, I will have a chance to share with you about the global pandemic. We just finished the introduction section, and let's move quickly to the main topic of today, the new labor code. Honestly, when the new labor code was passed last year, and there are several articles, workshops, and discussions about the changes under the new labor code. And some of the articles, they try to list down as much as possible and try to not forget anything. But because I got a chance to conduct several compliance training and updating about the new labor code is part of my job. I try to just deliver the key changes, notable changes under the new labor code to my audience and to my clients' staff, because based on my own experience, any items, any content that have been more than 10 bullet points or small part would be too much for the audience or for the attendee to remember. And so fortunately, you only have like 10 things to remember, hopefully, under the new labor code. The first one, additional holiday. For Vietnam, the national holiday is the 2nd of September. And once we have the new labor law, the national holiday will become a 2-day holiday. And whether the additional holiday will be before the 2nd of September or after the 2nd of September will be subject to the discretion of the Vietnamese government each year. But the good news is that starting from 2021, Vietnam and the employees will have 11 public holidays. Is the official news. Second, fewer types of labor contracts. Currently and previously, Vietnam Labor Code has 3 types of labor contract. The first one is indefinite term labor contract. The second one, definite term labor contract. And the third one, seasonal labor contract. And the seasonal labor contract is often used to conduct like short-term job or tasks, and it's not really commonly used in practice, and maybe that was the reason why under the new labor code this type of labor contract no longer exists. But the question is whether it's actually disappear. I'm going to show you shortly. The answer is no, because though now we only have like 2 types of labor contract, when the new labor code becomes effective, the seasonal and specific job contract is now part of the definite term contract. And so if you are asked about how many types of labor contracts under the labor code of Vietnam, you can simply say there are only 2. Indefinite term or indefinite term labor contract. 3. Limits on fixed term labor contract. I'm going to share with you the similarity of the current labor code and the new labor code. In general, it is only permissible to sign 2 definite term, or it has another name, fixed term labor contracts, and they can be of different term length. The third one must be an indefinite term labor contract. I want to elaborate on this point a little bit. So when we say about 2 definite term labor contract, it means that the maximum term of two fixed-term labor contracts that you can sign with the employees is 2 times of 36 months. So as a matter of law, you can sign 2 definite term labor contract with the employees having the term of 72 months. And if you want to still work with them and you want to sign the third labor contract, the third one must be an indefinite term labor contract. And this is another situation where you are required to sign the indefinite term labor contract with the employee. Is when you forgot to inform the employees about the expiry date of their first fixed-term labor contract. Because by law, you need to inform the employees of your intention to not continue signing the labor contract with them, and as well as to inform them about the expiry date of the first fixed-term labor contract. And if you forgot to do that and the employee continue working, to protect the employees, the labor law, the labor code requires you to sign how to say that? Oh, the law, it just like has an automatic requirement that such fixed-term labor contract will automatically become an indefinite term labor contract. So this is a similarity of the current labor code and the new labor code. What are the new things? Below are the new things. The first one, there is an exception for elderly employees. And when I mentioned about the term elderly employees, they are target to the employees who just passed the retirement age. So in this case, if they are still capable to work, they are allowed to continue working on definite term contracts. So there is no limitation for elderly employees in this situation. The second new things on this point is that the terms of labor contracts of expat employees must not exceed the terms of their work permit. And as you may know, if your current investment relating to Vietnam, the maximum term of the work permit is only 2 years, but you can renew it multiple times. So it means that from the strict view of the law, if you intend to hire an expat employee to work in Vietnam by signing a labor contract, then you cannot sign indefinite term labor contract with expat employees. And so you only have one choice to sign the definite term labor contract with the duration not exceeding 2 years. This is their work permit. And this is one related matter because like I've and my team works a lot on the labor aspect, and we also have our clients to obtain work permits as well as the certification on exemption of the work permit. And if the intended expat employee falling within the exemption, then you need to obtain the certification for exemption for them. But even when they have the exemption, the duration of the certificate is still 2 years. So the work permits or the work permit exemption certificate have the same duration of maximum term to 2 years. Number 4, at-will unilateral termination by employees. So before the new labor code in Vietnam, all lawyers can confidently say that in Vietnam we don't have at-will unilateral termination. But now, after the effectiveness of the new labor code, the employees can conduct an at-will unilateral termination. It means that the employees will be allowed to unilaterally terminate their contracts without providing any reason, provided that they meet the requirements for advance notice or advance notification. So previously, they need to satisfy two requirements. First, the advance notice, and second, they have to have a reason. But now they only need to follow the requirements for the advance notice. And I just create a table about the advance notice for each type of the labor contract for your ease of reference. And you can see that if you sign the indefinite term labor contract with an employee and they want to exit from such a labor relationship, they can simply provide you or give you an advance notice of at least 45 days. And the advance notice duration for the definite term labor contract, which have the duration from more than 12 months to up to less than 36 months, is at least 30 days. And for those definite term labor contract having the duration of less than 12 months, the employee is required to serve an advance notice at least 3 days. Number 5, clearer protection from sexual harassment. Okay. Thanks to the new labor code, for the first time, Vietnam officially provide an official definition of sexual harassment. And here it is. Any act of a sexual nature in the workplace of one person against another person against the latter's will. But just to share with you, if you just copy and paste this explanation definition into your company's internal labor rules or your company work rules, it will not be enforceable. It means that you need to specify in detail, and so that if there is one of the employee, they have an offense relating to a sexual harassment, you can conduct like the dismissal, because now sexual harassment has also been added to the list of offenses subject to the penalty of dismissal. Number 6, independent employee representative organization is allowed. At this moment, if you have like more than 5 employees and they want to set up their trade union within the company, so the employer need to support the employee to set up the company's trade union. But when we have the new labor code, the employees now has the right to ask for the formation of another representative organization. So this organization is different from the company's trade union. Honestly, I and my colleagues have no idea of what types of this organization, because like even the company's trade unions, just recently the foreign invested company started to form it within the company, and it's been a long time that the grassroots trade union is not preferable by the foreign investor doing business in Vietnam. But just wait and see. Number 7, validity of electronic labor contracts. So now labor contracts conclude through electronic means, such as by email, we have the same validity as printed paper contracts. So the labor code just recognize this fact. And in theory, and as a matter of law, you can sign electronic labor contracts, but based on my own experience and based on the practical aspect of Vietnam, maybe it's still advisable to sign the printed paper contracts. especially because it is the document you are dealing with the employees, and the labor code is to protective for the employees. So at least in the short term, in the near future, it's still advisable to sign the printed labor contracts. But maybe after 1 or 2 more years, the electronic labor contract will become more popular, and you can confidently use this method to sign labor contract with employees. Number 8, so we are coming to the end of this session, so we still have 8, 9, and 10, right? No direct interference in salary structure. At this moment and previously, when your company set up the scale of salary, you need to consult with the labor authority, and even you need to register your salary scale and salary structure. But after the new labor code becomes effective, such requirement no longer exists. As long as your wage scale meets the regional minimum wage set by the government. And so, for your information, the current minimum wage for the big cities like Hanoi and Ho Chi Minh City is nearly $200. Number 9, increase in retirement age. Wow, you know that the National Assembly of Vietnam has several meetings about this aspect, and finally, when they approve for the new labor code, they all agree to increase the retirement age of both male and female workers. And now the retirement age is 55 for women and 60 for men. But in after January 1st of next year, it will increase, and it will increase. I will pause at this point because the maximum retirement age after the effectiveness of the new labor code would be 60 for women and then 62 for men. But it doesn't mean that starting from next year, the women can work until 60 or the men can work until 62. This is because this change will be phased in gradually, with the retirement age increasing by 4 months each year for women and then 3 months each year for men, until the new limits are reached. Though it seems to be a long sentence, I'm going to give you an example. Next year, 2021, the retirement age for women would be 55 plus 4 months. And the retirement age for men in 2021 would be 60 plus 3 months. So you can keep doing the calculation this way. Hopefully that it would not be too difficult. And last but not least, more overtime allowed. Wow. If you are a Vietnamese employee, now you are allowed to work more. I have no idea if it's a good news or not, but as long as you are capable to work and your health status can meet the requirements of the job assignment, so it should not be any problem. Previously, I mean that under the current labor code, the maximum overtime is 30 hours per month, 30 per month. And once we have the new labor code, the maximum overtime per month would be 40 hours. And I'm going to share with you a related definition of overtime. Overtime work is the duration of work performed at any time other than during normal working hours. And this working hour needs to be specified in the law, in the collective bargaining agreement or internal labor rules of the company as an employer. And the normal working hours in Vietnam is 8 hours per day, and then it would not exist 48 hours per week. We just went through the 10 notable changes under the new labor code, and hopefully you can remember some of them subject to your major, your position in the company, and hopefully it would be helpful for you. And after you have been aware of such notable changes, you can just review some of the important internal labor-related documents in your company, such as the internal labor rules, or the work rules, or the company rules. Second, the labor contract templates, especially those relating to expat employees, to ensure that they are all compliant with the new labor code. And other than such three main documents, if your company set up a separate benefits policy for the employees, so please conduct an audit of this type of policy as well. This is to ensure that you don't have any contents or regulation that contradict to the new labor code. I'm going to move to the next slide to show you that there are some important provisions commonly appear in a labor contract of foreign invested company in Vietnam. The good thing is that they would not be impacted by the new labor code, and this provision relating to confidentiality, trade secrets, data privacy, IP rights ownership, IP right assignment, and the like, non-solicitation, non-compete. There are some special marks on non-solicitation and non-compete, with which I will share details with you on the next slide. Special training course. So in front of you are some of the important matters often covered by the labor contract of foreign invested company in Vietnam. And let's talk about restrictive covenants relating to some of them. The not good news is that legality not directly addressed under labor code for such things, except for the confidentiality and non-disclosure agreements or provision. Non-solicitation, it means that if you require your employees not to do solicitation of your customer and employees when they left the company, so this requirement could be enforceable, but based on my experience of handling several labor disputes, it mostly depends on the goodwill, the good behavior, the good manners of the employees. Maybe at the time of they are your employees, they have a very good gesture and a good manner, but after that they change. So it's still really hard to enforce this type of obligation, but it's still enforceable at some extent. How's about the non-compete obligation of the employees? Unfortunately and seriously, it's really hard to enforce the non-compete obligation. So even for helping the client to draft the labor contract templates, we always add in the non-compete obligation of the employees with the hope that it can give an advance warning to the employees who somehow have some intention to gain some personal benefit from the competitor of the company, but it still need to be subject to the goodwill and to the characteristic of the employees. So even it's hard to enforce the non-compete obligation or non-compete clause under labor contract, there's still a solution for this matter. It means that other than the labor contract, you can sign with the employee a separate agreements on confidentiality and non-disclosure. This way, their non-compete obligation and their confidentiality obligation can survive after the termination of their labor contract. Yeah, so there's still a way for this matter. We just complete the second part of my presentation, which is the new labor code. And so we will now move to the third section, the new normal. Okay, the pandemic has a devastating impact on the world economy. Everyone knows about that, right? But for Vietnam, it's introduced some advantages as well as disadvantages. Is that correct? I think personally, I think it's correct because I think that we just apply the working from home policy similar to most of the country, and many high-tech and white-collar jobs can be done remotely, offering flexibility and opportunities as well as challenges. I'm talking about like as an employer, how can you manage the work performance of your employees, and if this is like the case when you need to work with local partners or the business partner, but their internal system are not allow them to conduct a meeting through Zoom, for example, and they can only conduct meetings through Teams, another application, but now your system only allow you to conduct online meeting to Zoom. So we, as a law firm, we assist several clients, and we actually need to deal with this type of difficulties. And because the pandemic is still going on, and with the hope that the vaccine will be finally like reach to the end of the research, but at least in the near future, the pandemic in the pandemic situation, the work from home policy is still applied. We just talked about like the white collar jobs. How's about the jobs relating to factories? So why manufacturing does not lend itself to work from home? Some changes from the pandemic will be lasting, that's for sure. And then the hygiene and ventilation are crucial not only for pandemic prevention, but for employee welfare. And just like in Vietnam, employees now work on shifts more frequently. We're not talking too much on this point because I myself attend several webinars about work from home policy and how company adapt with like the new normal. So I believe that each company will have their own policy to manage their team on the work from home method or for the in-person working. This slide is very interesting. Like it's interesting for lawyer, but I'm sorry to say that, but it may be not interesting for the employer. And this is like the fact that in Vietnam there was an increase in labor dispute due to the COVID-19 because many businesses struggled during the pandemic, and as a result, layoffs and consolidation come along. And terminations can easily lead to dispute over compensation because from the employee's position, when they lost their job, they want to ask for more and they want to ask as much as they can. But from the position of the employer, you need to follow like the internal policy for paying the compensation, or even when you pay the some like living package. And in the next 2 slides, I'm going to share with you a typical case study on the labor dispute that I myself and my team just recently handled. Case study, retrainment for termination, retrainment or redundancy. The facts are as below. There was change in the organization structure of the Vietnamese subsidiary, and as a result, a senior manager position became redundant and it was merged into a regional role to be taken by a staff member of the employer's related company. And the employer was currently hold the general director as well as the legal representative position of the company. And the company wanted to amicably terminate the employee's labor contract with the reason of redundancy or retrainment. When the clients came to us with this situation, then they asked for our help. We are actually faced with some difficulties. First, the company may retrain the employee only if the company as an employer is unable to arrange a new job for the employee. But strictly speaking, by law, the company is required to offer the employee a new role within the company after the restructuring, if one is available. But unfortunately, no alternative role might be available in the new structure at the employee's current position. And though, if the company terminates the labor contract with the reason retrainment, they did not need to offer or pay the job loss allowance to the employee. The company still offer an ex gratia amount to the employee. But in this case, the employee demanded a too high amount. Let me recall the amount equivalent to about like 24 months of salary. And of course, the employer didn't agree. So how we help our clients? Actually, the best advice in this scenario is to close the case in an amicable manner. And because the employee is the company representative, the legal representative, and the general director, when the employer removes this position, it will come along with a lot of paperwork to amend the company's incorporation license. So we still need to obtain the signature of the employee in several documents. That is why it is like a must to close the case in an amicable manner. And because of that, we need to structure the retrainment termination as a mutual termination. So to clarify, the retrainment or the redundancy reason should only be used as leverage to negotiate on the leaving package of the employee. You cannot just like give a call to the employee and saying that, hey, the parents company restructuring the business, including Vietnam, and so you're gonna lose your job, and we will conduct like the redundancy procedure by law. It will never work that way, and it will lead you to sudden risks. In our experience, to negotiate with the employees in this case, you may need to prepare several packages to offer the employee from the lowest level to the highest level. And you may need to have a number of meetings with the employee to get his or her consent to the termination. But honestly, there was a case, not this case, but there was a case when we prepared like all scenarios from the lowest level to the highest level. At the first meeting, when we offered the lowest level, and then the employer, he suddenly got back with the amount which already is the highest level that the clients prepared. So please be prepared for that situation. And just try to be patient in this situation, and it's advisable to find like the most trustable or reliable in the company, because based on our experience in each company, there normally have one person that the other people may respect with most respect. Yeah, it doesn't need to be the general director or the legal representative, but maybe the most senior people of the company. So try to sort some help from inside to get the employees' consent to the termination. And what if after several meetings, discussion, negotiation, the employees refuse to accept the mutual termination? So if this is the case, we have only one choice. This is to proceed with the procedure for redundancy-based unilateral termination, because the law allows the employer to unilaterally terminate the labor contract based on restructuring or reorganization. And if in this case, there are at least 5 steps the employer needs to conduct. First, the investor or the parent company of the company needs to issue a resolution decision for conducting the reorganization. And you can look at step 2. The company then needs to issue a resolution for reorganization of the Vietnam entity. So if you just glance through this step, you may think that, hey, it looks like the same, right? But actually it's not the same. They are not the same. The step 1 relating to the must-have document issued by the investor. The second one relating to the must-have document issued by the company itself. Both documents are crucial because this evidence for the actual restructuring and reorganization. If you miss one of them, you may lose the case if the employees decided to bring the case to the court. Step 3. The company needs to inform the employees of the labor contract termination and then given prior notice to the terminated employees. To clarify, the requirement for sending the notice is not required by law, but the employer is encouraged to do so. The common notice should be 45 days in advance, and it's a normal practice to give pay in lieu of notice. It means that the employee doesn't need to go to work, doesn't need to go to the company. They can stay at home, but they can still receive money for such days. Step 4. The company needs to issue a decision on termination of the labor contract with the employees. And this step can be done together with step 3 in practice. And step 5. The company as an employer needs to pay job loss allowance, if any, and settle all other benefits to the employee. Why I mentioned that needs to pay job loss allowance, if any, because if any part of the job loss allowance were covered by the insurance, social insurance, so the company in theory doesn't need to pay the job loss allowance. Yeah. And this 5-step procedure belong to the procedure for restructuring organization only relating to one person. It means that you don't need to form what is called as a labor users plan to lay off one person. But if you intend to lay off more than one person with the reason as restructuring or redundancy, you are required to work with the trade union organization to prepare the labor users plan, which is clearly address the reason for the reorganization, restructuring, and then the intended new job or new position of the impacted employees. And of note, under the labor law, terminated employees who has worked for the company at least 12 months is entitled to job loss allowance, which is now 1 month salary for each year of service. Okay, I repeat this part. At least 12 months, if the employees work for the company at least 12 months, they will be entitled to a job loss allowance. And the job loss allowance by law is 1 month salary for each year of service, but in no circumstance not less than 2 months salary. But the length of the service for calculation of statutory job loss allowance does not include the period that the employee has participated in the statutory unemployment insurance scheme. We just go through the 3 important part of my presentation today, and actually this is only one section left, labor discipline. It's always need to be a focus, and if you attend my presentation last year in person in Bangkok, and actually I spent several times discussing about the labor discipline. So this time I just want to take like a few minutes left to emphasize the importance of the regulation on labor discipline and some key regulation that you should be always remember if you can. Yeah, if you can. When you talk about labor discipline, and the law allows an employer a few measures to do it against the wrongdoer within the company, and such as reprimand. Second, deferral of wage increase for a maximum of 6 months. And just want to clarify one point. For deferral of wage increase and demotion, you can see that the third one, demotion. If the employee recommits a second offense during the deferral period or after demotion, the employee may be dismissed if the ILRs or the work rules, internal labor rules, so provided. So reprimand, deferral of wage increase for a maximum of 6 months, demotion or dismissal. Let's talk a little bit about disciplinary procedure. Generally, to deal with violations within the company, you are required to provide or stipulated clearly in the work rules, and the labor code requires you that the following things. The breach must be clearly set out in the work rules, as I mentioned, and the employer must be able to prove the employee's fault. This is the most difficult part, to prove the employee's fault. Second one, legal procedure formality must be followed. You need to consult with the trade union and get them involved in the disciplinary procedure. And the employee must be present, and he or she has the right to defend himself or herself, or they can employ a lawyer to do so. In all circumstances, try not to let the employee get the lawyer involved, because it may lead the case to unnecessary complication. That is why in most of the case, when we help our clients to handle a labor dispute, we always play the role of the behind the scene. We always be behind the scene. So we prepare most of the documents required by law, provide like in-demand requests, but we limit our presence during the meetings or negotiation between the employees and the employers, the wrongdoer. This is to avoid like the unnecessary pressure from the side of the employees. Otherwise, they will try to push back and try to give the threat that hey, I will bring along to the meeting a lawyer who will represent me to deal with you. And this is like a small note which relating to the time limits for dealing with breach of the work rules or the internal labor rules. For breach relating to finance, we talk about money, right? The time limit is 12 months from the date the breach occur. And this is a similar time limit for a breach relating to disclosure of technology or technological or business secrets. And for other breach, the time limit for dealing with the breach, it means that for taking a disciplinary action against the wrongdoer is 6 months from the date of the breach. And we are at the slide about dismissal for serious violation. Okay. I just need your attention to the bold contents because the other things may be similar to other jurisdiction. So if the employees commit an act of theft, embezzlement, gambling, assault, blah blah, or commit other action that cause or threaten to cause serious damage to the assets or interest of the employer or the company. I would like to note about the serious damage here. Based on my experience and the firm's experience, you need to specify the level of damage clearly in the work rules or the internal labor rules. And if possible, please specify specific amount of money. For example, 5 million Vietnam dong, 100 million Vietnam dong, yeah, something like that. And it would be very helpful for you to dealing with this type of breach of the employee. And you as an employer can dismiss an employee if they already been disciplined by deferral of wage increase and recommits an offense while he or she is still within the period of disciplinary actions, or recommits an offense after being disciplined by demotion. Yeah, like in the previous slide I shared with you. And the third situation that you can dismiss an employee if he or she takes a total of 5 days off in 1 month or a total of 20 days off in 1 year without proper reason. You can see that I have some marks in green for this slide. And why? It's because under the new labor code, they added one situation when the employer can also dismiss the employee, which is when such employee commits act of sexual harassment. You remember one of the 10 notable change I shared with you in section 2, right? Okay, so now sexual harassment has been added to the list of dismissal. Illegal unilateral termination. Of course, by law, you are allowed to unilaterally terminate the labor contract in certain circumstances as long as you can prove the faults of the employee. But the law also set out a few cases where you are not allowed to do so, or if you do the dismissal, you will be considered illegal. If the employee is sick or recovering from a labor accident, okay. During the COVID-19, the government also issued some official guidance on the sickness things, which is covered like the recovering from the COVID situation. Yeah, here is it. And you are not allowed to dismiss or terminate a labor contract with an employee if he or she is on annual leave or on other permitted leave including on maternity leave or caring for a child under 12 months. And there's also a case where the law does not allow you to terminate the labor contract with the employee if you not follow the required notice. Compensation requirements. So we only have like 2 or 3 slides left for this section and for this presentation. So I just want to recall that for legal termination by employer, if due to serious disciplinary violation, you are not required to pay any severance allowance to the wrongdoer or the employees who commit an offense. For all the types of legal termination by employer, you will need to pay severance allowance which equal to half month of salary for every year of employment if the employee is employed for more than 1 year. And if you terminate a labor contract using the reason for retrenchment, redundancy as a result of a restructuring or reorganization of your company, you need to pay a job loss allowance, which is equivalent to 1 month's salary for each year of service of the employee, and in no circumstance would be less than 2 months of salary. But this is one important note here. For period of contribution to unemployment insurance, unemployment allowance in lieu of severance allowance or job loss allowance will be covered by the social insurance fund. It means that if your company strictly follow with all of the payment obligation with the social insurance fund, maybe you don't need to pay the job loss allowance or the severance allowance in case you do a legal termination. And the last slide, I'm going to repeat about some practical advice that would be helpful for you when you need to deal with the termination. First, you need to gather as much evidence as possible. This is like one of the most important tasks that you or like your HR staff need to do. And because this is a key to help the position of the employer, if you can gather the strong evidence and sufficient evidence proving the wrongdoings of the employee, you can finish and close the case quickly. So please do take time for collecting evidence. Second, if the employee contests the termination, it is very expensive and troublesome for employer to unilaterally terminate a labor contract. So if staff are improperly terminated, you may be forced to take them back. This is the thing you don't want to do, right? And for certain cases, the litigation procedures may extend to 3 to 10 years, and then other than you need to take them back, you need to pay all of the interest, wage, salary during the dispute time. So you can imagine that you need to pay a lot of money. So please try to handle the case in an amicable way and try to reach a mutual termination with the wrongdoer in your company. That's maybe a very time-consuming process, but it would be worth to do that in comparison with like the 3 and 10 years cases I just shared with you. And the last but not least thing, when you already collect sufficient evidence, you have a strong evidence, it's about the wrongdoings of the employee, and you're confident that you can conduct like a legal termination. So you need to follow the requirement on the advance notice to inform the employees about the termination. within the duration required by the law. And so this slide is the last slide of my presentation today and of this year. I hope that you may find some of the slides and hopefully all of the slides helpful for you and for your company. And should you have any question, you can contact me. Oh, and then where's my information? Okay, it happened at the last slide. Yeah, you can contact me through my email or through my direct line. So should you want to contact me directly from other countries to Vietnam, so please feel free to dial in. And thanks for a lot for your time today. And I wish that your companies will be doing well despite of the COVID-19, and all of you will be in a good health. So thank you. Well, I just went through like the published question in the live event Q&A, and thanks for all of you who have sent me the questions. And so I'm going to answer, hopefully most of them if we have sufficient time. When I prepare the presentation today, and then when I review the draft of the new labor code, there was actually one thing that drew my attention, which is about the requirement for the term of the labor contract for expert employees. So, and I can see that there are several questions about this point. And to be honest, this is one of the most important change under the labor code. Personally, I think that. And so then let's go to the first question. If at this moment you already signed an indefinite term labor contract with your expert employee, so what happened to them after January 1? In this case, so I just share my personal opinions, because like normally, as long as when we have the law effective, and then we will have some guidance, and then when the labor authority collects some similar questions like the one I received today, it also my concern, they will issue an official guidance on this point. But maybe just to answer your question, what happened to the indefinite term labor contract with expert after January 1st next year? So if their work permit is still valid, maybe we need to amend the indefinite term labor contract, and then we need to change the type of the labor contract into the definite term labor contract. But this is one thing. The law are not allowed, like the employer and the employees, as I remember, to like amend the labor contract, to amend the type of the labor contract. So maybe for prudence, and in the condition that the work permit is still valid, you may need to liquidate the existing indefinite term labor contract, and then you sign the definite term labor contract. This is just like my personal opinions. And if like in the near future we receive more guidance, official guidance on this point, we will send an alert to all of our clients on this section, on this part. And if we talk about like whether the indefinite term labor contract with expert will automatically become a fixed term labor contract with the same term as the work permit. So this is, I can say that the answer is no. You cannot like leave it as A and then can imply that the indefinite term contract can be automatically become a fixed term labor contract with have the same duration of the work permit. So like I shared with you, if we are put in this position, maybe we will have our clients to liquidate the existing indefinite term labor contract, and then with an undertaking that the parties will be sign on the new fixed term labor contract to comply with the new law. And as I share with you that signing into an appendix to amend the type of the labor contract may be feasible in only particular this case, but from the strict view of the law, it is not allowed to do so. So I might prefer with like the first option, which is like liquidate the existing labor contract, indefinite term labor contract, and sign on the new one with the fixed term labor contract, with the fixed term similar to the work permit duration. So I think that is safer than like signing an appendix to amend the type of the labor contract. But maybe because like this is a very dedicated situation, maybe the law, the future guidance from the regulator may accept like even the second option, that the parties can sign on an addendum on annex to the current labor contract. Yeah, so let's wait and see. So I myself would prefer the first option, and then for the second option, let's wait and see whether we have like any official guidance from the labor authority on this aspect. Yeah. And I also received one questions about the e-labor contract. Yeah, thanks for raising this point, because even all of us talk a lot about e-labor contract, and the law, the new labor code accepts this form, provide that it meets the requirement of the e-transaction. So I might elaborate this point a little bit based on my own experience, because again, currently we have no official guidance on this point. To satisfy, if talking about the e-labor contract, so first it needs to satisfy the requirements of the content of the labor contract as provided by the labor code first, which is like it needs to set out like the job title, description of job, duration, and some key rights and benefits of the employees and the employers. And maybe it needs to adding, you can say a disclaimer that the parties fully aware or acknowledge that the labor contract has been made by electronic way. So we need to specify this point in the labor contract, and then all the done requirements provided by the labor code. It is correct that it still needs to meet the requirement for the e-transaction. And we're talking about like the security aspect of the e-transaction, and then maybe for the e-transaction, the representative of the company needs to register the e-signature. Yeah, he or she needs to register the e-signature, and this is a separate process to register the e-signature of the legal representative of the company. So at least from the aspect of the e-transaction, you need to obtain a proper e-signature of the employers. So this is one thing. And I also have another question. The first one again relating to the work permit and the fixed term labor contract, which I already addressed it. And the second one, I will read it now. The term of an employee's labor contract is currently fixed at 12 months. Under the new labor code, can the company sign another definite term labor contract with him or her with a shorter term, less than 12 months, which is same with the seasonal contract under the current law. Okay, so when I read this question, the first thing coming in my mind is that you are talking about the situation where we have only one employee, but potentially having two labor contracts. And because this is part of the question, so I assume that the another definite term labor contract relating to another job or task or assignment. Otherwise, it may not make sense, right? Okay, and so if like the another definite term labor contract relating to a different job title, so the answer is yes, because like the law does not limit the numbers of fixed term labor contract relating to different jobs, tasks or assignments. But if your question relating to one employee with only one position with the same job description, then the answer would be no, because like the regulator may view this action as like the action try to hide an improper job or the like, and so this is what I thought, and so I think that I've just went through like 5 questions, and 3 of them relating to the work permit and the term of the work permit, and then the maximum term of the fixed labor contract signing with foreign employees. And so if I had a chance to clarify, if I had a chance to know more details about any official guidance from the regulator on this aspect, I will reflect it in the client alert, and then our marketing team will have to send such alert to all of you. And the e-labor contract is also like an interesting thing and new things, and hopefully it will be enforceable in practice, and so that if this is the case, the employers in Vietnam will have like less paperwork to do, honestly, and so we are just on the right track, and we are coming at the end of the presentation today. So should you have any follow-up question, you can email me or contact our marketing team. And so thanks again for joining me today, and thanks again for like sharing me my concern about like the duration of the work permit, the duration of work permit, and then the indefinite term of fixed term labor contracts. Yeah. Thanks all for your participation in my presentation today, and goodbye. Yes, and goodbye.